Good morning. Happy Saturday. In the video that I made about Maddy, where I suggested that she was concerned that her criminal case for intercepting communications had not been dropped, I did state that her case about intercepting communications is going to be a tough slog for her. It's going to be a long road to hoe because there is no authority. There is no direct authority that stands for the proposition in any circuit that I'm aware of that stands for the proposition that you can record a government official from a phone call in in an all-party consent state. So just because the government calls you doesn't mean you get to record it. At least that hasn't been found in any circuit that I am aware of. And it certainly hasn't been established in the United States Supreme Court. And I did a quick check of it for Florida, and I couldn't find anything from the Florida Supreme Court to stand for that proposition. And so I just said it's a tough road to hoe. It's going to be a hard climb. I'm not saying that it's insurmountable. I'm saying that there is a very good possibility, a strong possibility that Maddy will lose. Not that her claim doesn't have merit, because you got to remember that it was a century or so of civil rights cases that were rejected by courts until finally they started accepting them. And we started getting some movement in the civil rights fronts. So just because I don't believe that her case will be fruitful for her doesn't mean that it can't, and it doesn't mean that it shouldn't. I'm just telling you that I don't think it has a good chance. But Brian B. thought it does, and he cites McDonough v. Fernandez-Rundle, which is an 11th Circuit Court of Appeals case. And he says it cleared this up. As for recording government officials in secret, which is permissible under the law as long as the government official is in their official capacity officially. And that is entirely not an accurate statement of what McDonough v. Fernandez-Rundle concluded. There is nothing in McDonough v. Fernandez-Rundle that says you can record government officials as long as they're acting in their official capacity. Nothing in there, nothing. Zip zero, nothing, nada, zilch, nothing. So I understand that most people don't read these cases and that they find someone else's interpretation, but I do read the cases. And so we're going to go over some of the reasons why McDonough v. Fernandez-Rundle isn't the magic bullet. And before we get there, I do want to start off with a little bit of civics for people, just so everybody is on the same page. The way the court systems work is that state courts are the ultimate deciders of what state constitutions mean, of what state laws mean, and of whether or not state laws are or are not constitutional under the state constitution. They have the ultimate power to decide those things. They may also decide whether or not a state law is constitutional under the United States Constitution, but their decision on that front has to defer to the federal courts. Federal courts are the ultimate arbiters of whether or not a state law or any law is or is not constitutional under the United States Constitution. They are required to defer to state courts' interpretations and understandings of law, or at least they're supposed to. So if it is a question of what does the state statute mean, and what are the elements of it, and what are the definitions of the particular words in it, etc., that is up to the state. If it is a question of whether or not this particular statute violates the First Amendment of the United States Constitution, that is up to the federal court, ultimately at the end of the day. So what happened? Let's go over what happened really quick, because the facts aren't terribly important, but we do need to know a few basic facts. McDonough went to the police chief's office, where there were 3 other people present, the police chief and 2 others. So there's 4 people present at the police chief's office. He decides to record that conversation, and he records a portion of that conversation. And then after he recorded that conversation, he received a letter from a state attorney, Fernandez-Rundle, threatening him with arrest, essentially, if he disclosed he'd published it. So if he continued to publish it, I guess, she threatened him with a felony prosecution for having violated Florida's SCA. I forget exactly what that stands for. It stands for Security of Communications Act. And so because he was threatened with this prosecution, he filed a 1983 lawsuit seeking injunctive relief. He did not allege in the lower courts, my understanding is he did not allege in the lower courts that Section 943.03, the SCA, did not apply to him, but he did allege it violated the First Amendment. And in the district court ruled that the SCA did not violate his First Amendment right because the court used a forum analysis and said that in the police chief's office, that is a non-public forum. And so you get the rational basis review. All that the statute has to accomplish in order to be constitutional for the rational basis review is it has to be rationally related to a legitimate government interest, and it has to be viewpoint neutral. That's it. And so under that kind of ground, this particular statute is constitutional. Now, right there, you should note that they're dealing with a very particular fact pattern that doesn't apply to Maddy. Because what is the forum analysis for an interception or a recording of a phone call? Because a phone call can take place anywhere, especially with cell phones. A phone call can take place in a public park. You can place the call in a public park. The other person can be receiving the call in Times Square. I mean, both parties may be in a traditional public forum, and that's not something that the statute really addresses. So I don't know why the lower court did a forum analysis other than the fact that this particular meeting took place in a non-public forum. So McDonough, who lost at the district court, appealed. And the appeals court decides that it is not going to look at whether or not the SCA, the Florida SCA, is or is not constitutional. They never even reach whether it is or isn't constitutional. They never look at it. They don't examine it. They just ignore it. And they say that because what McDonough did was intercepting an oral communication. There's 3 kinds of communications. There are wire communications, which basically mean anything that goes through wires in whole or in part. There's oral communications, which is just someone saying things. And there are electronic communications somewhere down here, which are basically wire communications that aren't wire or oral communications. Hold on, let me find it. Electronic communication is basically any transfer of signals, etc., that does not include any oral or wire communication. So basically, it's the electronic communication is a catch-all for things that aren't wire communications or oral communications. Now, we know that you can record public officials in public. You can record anybody in public. And if they're saying something in public, even to somebody else, and you happen to capture that, and they're in a public place and you're in a public place, well, it's probably going to be good. It's probably going to be a valid exercise of your First Amendment rights. But the court never got to that. So the statute might be facially unconstitutional, or it might be unconstitutional in the context of Maddy communicating with a government official over the phone. Those are the routes that I'm assuming it's going to take. The problem is there's nothing in case law suggesting that this is going to work. And I do want to say one other thing is that the statute does require an expectation of privacy on the part of the speaker. The person who's being recorded, that person has to have some sort of an expectation of privacy, which means that if everybody was in a public park, the phone call was made in a public park, or if, the officer making the arrest in public, does he have an expectation of communication or expectation of privacy? Who knows at that point. So, and for those of you who are going to say, well, there's always no expectation of privacy when you're in public. There is. And once again, I've gone over it before. For example, you can't film up a woman's skirt, even if she's in a public park, because she has an expectation of privacy in public. So, I mean, there are exceptions. Let's not get into the comments and play stupid games to try to win stupid prizes. It wastes everybody's time, and I won't respond to it, just so you know. So what the Court of Appeals does is it says that the definition of oral communications exclude oral communications at public meetings, public oral communications at public meetings. And that is in here, right here. Oral communications means any oral communication uttered by a person exhibiting an expectation that such communication is not subject to interception under circumstances justifying such expectation, and does not meet any public oral communication uttered at any public oral communication uttered at a public meeting or any electronic communication. So what they said is that this was uttered at a public meeting because there were 4 people present. It was uttered at a public meeting, and therefore it is not an oral communication because it does not apply to oral communications, and therefore the SCA doesn't apply, and therefore it doesn't apply to Rundle. Congratulations. And then they also stated that there has to be a reasonable expectation of privacy exhibited. So what that means in terms of public meetings, i.e. having someone come to the police station and have a meeting with the police chief with 2 other police officers present, is that according to the interpretation of the 11th Circuit Court of Appeals, the public official or other attendees would have to state that they have some sort of an expectation of privacy. I'm going to assume that there is an expectation of privacy when you make a phone call, that it is just you and the other person who are going to be hearing the contents of that phone call. I'm going to make that assumption. If you ever wonder why a lot of companies will state at the beginning, this call is being recorded for training purposes or whatever, it's to remove your expectation of privacy. So you have to have an expectation of privacy, and that expectation of privacy has to be exhibited for public meetings. And so they don't get to whether or not it is or is not constitutional. They just say that it wasn't an oral communication. And so congratulations, it didn't deal with it. But remember, nowhere in here does it say that you can record a government official as long as the government official is acting in their capacity, their official capacity. It says that if they're in a public meeting, they have to exhibit an expectation of privacy. They have to actually make a statement. They have to exhibit it outwardly so that you understand they have an expectation of privacy, i.e. they have to say, this is off the record. You're not recording this, are you? Blah, blah, blah. They have to say something in a public meeting. So it has nothing to do with phone calls. And again, I'm not saying that Maddy can't win. I'm just saying that there is no case law specifically on point. Having the 11th Circuit Court of Appeals interpret the statute doesn't really mean anything because, again, the state is the ultimate arbiter of what the statute means. The state court gets to determine what that statute means, not the federal court. And because the federal court abandoned its responsibility to determine whether or not the statute was constitutional, We just don't know at this point. I'm guessing because other states have similar statutes that require all parties to consent that have been litigated as far as the First Amendment. I'm going to assume that the 11th Circuit is going to determine that this statute is also constitutional. And if they don't, then I'm sure that it will go to the U.S. Supreme Court. Well, I'm not sure, but there is a reasonable probability that it will go to the U.S. Supreme Court. So anyway, I hope that was educational and informative. I hope Brian B doesn't take too much exception for me pointing out his error. And again, it's not a crime to not be an attorney. I mean, we don't. I would make a terrible plumber. So we all have our jobs and our knowledge bases. Thanks for watching. Have a great day.